year, and there's been a lot happening at the Supreme Court. This week is the penultimate week of oral arguments with a number of very interesting arguments. We'll talk to my colleagues, senior attorneys at PLF, Damien Schiff and Oliver Dunford. There were also some opinions in the last 2 weeks, and also some sort of Supreme Court gossip going on, and leaks and apologies and other things that we'll get into towards the end of the show. But we'll start with the oral arguments before we go to the opinions, and let's just start with what I thought was the most interesting argument. It wasn't the first one of the week, but it's one that I think when I was listening to it, I was thinking of both of you. This is the FCC versus AT&T case. And I was thinking, of course, of Oliver, because you deal a lot with agency adjudications, and you're dealing a lot with separation of powers issues. And then Damien, you litigated Sackett, and the first Sackett case that you argued before the Supreme Court dealt with this thing called compliance orders, which threatened the Sacketts with fines of up to $75,000 a day. And the government's response in that case was, oh, this isn't final agency action, and you can't sue over it, and there's nothing really happens until we come after you. So these are the ideas that are floating around in my head, and I want to talk to both of you about it. So Oliver, why don't you lead us off, just give us an overview of the case.
Yeah, so in this case, the FCC sent, as you said, notices of violations, one to AT&T, one to Verizon. They fined them, I forget, or proposed to fine them tens of millions of dollars.
It was $100 million.
All right, and then so the companies have an option. They can pay right away, and then face and seek review in-house, or they can refuse, and then they can wait for the Justice Department to file suit in federal court, and then either way, though, the argument is they're denied the right to claim a jury trial. They have to wait for the DOJ to bring it in court, or they have to go through the administrative process. And either way, they have no ability, the companies themselves have no ability to trigger a jury trial.
Right. And Damien, when I talked to you about it in the office, you seem to think that although there may be some sort of second one analogs, you didn't think it really mapped on that well to the case. And tell me why not.
Well, in part because here the petitioners were asking for a particular type of judicial review. As Oliver mentioned, that the statute provides a sort of administrative procedure type review on a closed record, but the petitioners wanted to be able to guarantee themselves an immediate jury trial proceeding on disputed questions of fact. Whereas in Sackett 1, we were just asking for any judicial review, even if it were limited to a closed administrative record. I do think, though, another difference here is that, in Sackett 1, the EPA really sort of doubled down on the legal significance of compliance orders as the case proceeded. Whereas just the opposite happened here. The Solicitor General, representing the FCC in briefing and then at the argument, essentially reduced these notices of violations or notices of apparent liability, forfeiture orders, whatever they were, to basically being just simply authorizations to DOJ to bring a civil lawsuit, and that they had no other legal significance, that they did not impose an obligation to pay immediately, that the failure to pay immediately would not itself be actionable, that there was no interest that would be charged, that the failure to immediately abide would not be used by the FCC in some future licensing proceeding. And so, given all of those concessions, whether or not they could be reconciled with the statute is another thing, but given those concessions, it did substantially, I think, undercut the force of the petitioner's demand for a more enhanced form of judicial review, because there just didn't seem, it almost got to the point where you thought, well, do we even have a final agency action? Is there even a legal consequence here, and is there standing? If truly these are such insignificant agency documents. I don't think it went that far, because even the Solicitor General was in agreement that they had a legal consequence of authorizing a civil lawsuit.
Right.
So, but that definitely changed the case.
The Petitioner's Counsel, I think at some point was responding to questions along the line of, he had noted in his reply brief that they had retreated so far that from the case that they actually granted cert on, that it was unclear what the agency's position was. And as you note, a lot of the consequence that was present in the case seems to have gone away by the time it got around to arguments. So Oliver, I have a couple related questions for you. I guess first is, one of the petitioner's points was, as Damien noted, this position is not reconcilable with the statute, in that there are oodles of these enforcement statutes throughout the United States Code with different agencies. They all say the same thing. This was really no different than what was the case from last term?
Jarkissi.
Jarkissi, and you're always sort of you're always like, the agency can always choose to take an enforcement action or not choose to. So I guess, what's your response to sort of that bucket of arguments here?
Yeah, it's interesting because the FCC obviously wants to protect its ability to do this in the future. The government's line is a combination of you don't have to do anything, and as Damien alluded to, they also say it's not a final agency action, and so there's these, they try to keep you out of court as much as possible. And for companies like Verizon and AT&T, they can afford to pay the $50 million, $100 million fine, and then hire Williams and Connolly to defend them all the way through. But it really hurts smaller entities. So one thing I was thinking when they were making these arguments is maybe AT&T and Verizon aren't the best parties to be bringing this case to the Supreme Court.
You need to sack it.
And even though the justices, for the most part, I think agreed that there was a problem here, but there's problems with making the arguments consistent with what the statute actually says, and then what they do from here. I think there was efforts by many of the justices to try to limit it to this case because of the concessions and everything else, and not try to draw or try not to make an opinion that would apply across the entire government.
Do you think the FCC statute is meaningfully different from these other statutes that authorize penalties in different agencies?
The weirdness is requiring payment first. That I don't know how common that is.
Well, and even that, as I understand, is the result of a weird DC Circuit decision, that the statute itself doesn't expressly say, it's rather that the statute says that you can get review of a different type of order that requires you to pay. And I guess the idea is, well, then if you get any other type of review, then you have to pay as well, because it seems inconsistent. It was very confusing to me as well, but yeah.
No, that's a good point. But Joshua, so on the broad picture, no, you can get a notice of violation from various agencies. Some, like the SEC, in some instances has the option to go in-house or in court. Many agencies do not. They have to bring it in-house, and you can litigate it there. You can then agree or not. I guess you can just stipulate, fine, we lose, and not pay and see what the DOJ does. Because technically these entities or the agencies cannot enforce their orders by themselves. They have to go to court for the most part to get these, to compel compliance. And so no, you're right. In the big picture, it's not different.
Do you find, I found it a little bit beyond the pale. This is part of my harkening back to Sackett. This reminded me almost straight out of the Sackett playbook. Is I heard the counsel for AT&T say something like, he was reading the actual notice of violation, like, you are ordered to pay $100 million and you have been fined this, failure to pay, blah, 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 blah. And I'm thinking, like, you're telling me that, granted, it's AT&T, they got high-powered lawyers, they're not some, landowner in northern Idaho. But how can you read that and say, like, oh, no, it's just a suggestion? We don't really mean that you're actually fined that.
Yeah, well, Damien and I worked on a case, I don't know, a year or two ago. Same thing. This is from the Consumer Product Safety Commission. It said you are ordered to do this, you must pay. And then even worse in that case was the CPSC could use the notices, which were supposedly non-binding and non-final, as evidence in the future of repeated willful violation of the statute. So it's not final, but it's also evidence that you ignored or that you knowingly violated the statute, because we put you on notice that what you've done violates the statute.
Absurd.
You know, I think this, I will say this is, it seems to be a unique statutory framework in that typically, if you don't pay an agency judgment or order, it's true that the agency has to go to court in order to, say, garnish your wages or something like that. But when you do get to court, you don't get to contest the merits anymore.
That's a good point.
Whereas here, as I understand it, that was kind of the force of the Solicitor General's argument in distinguishing jarcossy, because that was also true in jarcossy, is that the SEC would haul you administratively, and sure, you didn't have to pay the order administratively, but if they brought an enforcement action, you wouldn't be able to contest the merits. Here,
Yeah.
apparently, you are able to contest the merits and also get a jury trial
Right. I was
in
just
that
going to
civil
say,
action.
you also get a jury trial, whereas in the administrative hearings, you get the ALJ or the commission or whatever,
Right.
and then you go to court, and the courts have to defer to the fact findings, so you don't get a jury at any stage.
Yeah.
I just have the sense this case is going to end up being kind of ho-hum. I think
Yeah.
because of all the concessions, I don't think
Yeah.
much is going to happen.
9-0?
Possibly, yeah.
No, I think Gorsuch might at least concur in judgment or something.
Yeah. All right. Let's move on to the other agency case. This is Script Tech versus SEC. What's disgorgement, Oliver?
Who the hell knows? The term came up in courts apparently relatively recently, and it arose because the SEC initially, this is an SEC case, and the SEC initially had the authority only to issue injunctions effectively, and so no penalty, no civil money penalties. And so what the SEC would do then is would try to stretch its authority and say, okay, we're issuing an order, and as an incident to our equitable order, we're requiring you to pay restitution, or as it ended up saying, disgorgement.
So to be clear, disgorgement is paying, the wrongdoer pays the people who were whose money was taken from them.
Yeah, supposedly it's ill-gotten gains. You're supposed the company that allegedly defrauded whoever must disgorge those ill-gotten gains back to the defrauded parties. And so in a 2020 opinion, the U.S. Supreme Court said that the SEC could not use disgorgement if there were no victims. So if there were no fraudulent victims, then there's no disgorgement, and it's just a penalty. A few years later, the Congress amended the law and allowed the SEC to collect disgorgement. And so the question now is, does disgorgement still have the same meaning that it did previously when there was no ability to recover disgorgement in the statute? So in other words, it was a judicially created, SEC created remedy called disgorgement. Court said you have to have victims. Congress then said, okay, now you have the power, the SEC now has the power expressly in the statute to recover or to collect disgorgement. And the question is, what does disgorgement mean
And
now?
more specifically, as I understood it from the argument, what's at issue here is the company being disgorged is saying, like, you can't identify the victims. So
Right.
you can't just take our money under this disgorgement idea if you can't identify the people with whom you're going to give the money to. And I thought pretty persuasive as sort of rhetorical matter is that the SEC has taken something like, I don't remember what the number was, $5 billion in disgorgement in 2025, and it's actually given out only like 300 million. So
Yeah.
like a pittance of what they're actually taking, they're actually finding the victims for. And they're like, look, you can't continue to use this disgorgement theory if you're actually just essentially fining us. So if you're using a fining power, then disgorgement doesn't apply.
Right, and the best the SG could do at that point was something like 88% is designated for repayment. Uh, but who knows if they'll be able to do it.
I mean, why isn't it 100%, by the way?
Well, right. Well, there's some overhead, but who knows? I mean, you'd think that if they could identify the victims, it shouldn't be that hard. There were some interesting arguments about where the disgorgement was placed in the statute. There's an argument that it was placed in the penalty part of the statute. It just seems to me, though, that without defining it, it seems like the Congress adopted the term as understood by everyone before the amendment. So, meaning that you have to have victims in order to collect disgorgement.
Well, that's an interesting point because one of the amicus briefs that came up during oral argument was an amicus brief by a prominent remedies law scholar. And that brief argued that no, actually traditionally disgorgement didn't require a victim. That's not part of it, so.
Well, Justice Thomas, in I forget which opinion, in a concurring opinion, pointed out that what I said at the beginning, that the SEC initially had only equitable powers, no power to collect money, at least penalties, and that the term disgorgement was just kind of made up, again, fairly recently. I don't know, I haven't looked into it that deeply, but.
We're getting a little bit in beyond my knowledge, but I remember the discussion about unjust enrichment. Like they're trying to say, well, we don't want this company to benefit unjustly because if it did something wrong, then that money is not its to begin with. So we're not essentially disgorging them of the funds. They aren't entitled to those funds as an initial matter. But I just sort of think that just begs the question on whether recipients are necessary, right?
Yeah, and there's also there's legal restitution and there's equitable restitution. So it's difficult to do it just on the name alone, just what people call it. So yeah, there's a lot of interesting points.
I'm not even sure too even how important the victims are in that it seems like disgorgement is permissible even if it results in a windfall to the quote-unquote victim. So you figure that, well, if it's a windfall, how are they really victims? I mean, it almost seems like they just sort of winning the remedy lottery. But I actually thought Justice Jackson had a good point. She kept coming back to this, how, because the challengers were calling this a penalty. And that's one reason why it was unequitable. And it's also related to the Seventh Amendment issue in the background here, because if it's a penalty, then it's probably triggered the Seventh Amendment. But you made a good point that, if you're being deprived of your ill-begotten gains, then you're not being penalized.
Yeah.
You're just being put back into the position that you should have been to begin with. And then if you lose even more money, that's obviously the penalty, but that's meant to deter your, or otherwise punish your conduct.
Well, but then it just should be a penalty, I think, is the point. And there's a statute, or part of the statute allows expressly for civil penalties, and so that issue can be avoided.
So why doesn't the U.S. government just seek? Is there a reason why it would seek disgorgement over penalties?
Well, it's a good point. I don't know, especially if in court. I don't know that it makes a difference unless there's a cap, which I just don't know. We're representing somebody in the 10th Circuit right now. And the court, the district court, issued disgorgement and a penalty, and so our argument is there was a double penalty, and they're calling one disgorgement. And the same situation as Sripech, there's no victims here. The clients were more than satisfied, and no one was defrauded. So I don't know if there's a cap in the statute.
Is there a Seventh Amendment issue for one versus the other?
Yeah, yes. If it's disgorgement, it is arguably equitable. If it's a penalty, and actually at one point the Solicitor General made a concession to Justice Gorsuch, and I think he said, or maybe is this the other case? Maybe this is the AT&T case. I'm getting myself confused here, but one of the I am old, but it's still interesting. Justice Gorsuch asked the lawyer whether you can, the government, whether you can still collect this without a jury. Then it was basically the penalty. And he said, yes, that's our position. And Sotomayor, it was this case, because Sotomayor, I think, wrote. Anyway, Sotomayor said, well, I don't understand your argument. And so it seems like that could be a problem. If that's what the court agrees on that point, there could be a problem for.
Any predictions on how this case will end up?
No. I think it's a tough one. I think the whole disgorgement means equitable, but I'm not sure.
And so if it means equitable, then, well, is that even a dispute whether disgorgement means equitable?
No, it's a good point. So I think they'll say that for an award of disgorgement, there must be victims, and there were no victims here, and therefore
It was just a penalty.
revenge will prevail.
What's interesting in terms of the advocacy here is Mr. Shipich was represented by, just regular counsel in California below, and then the case was taken over by prominent SCOTUS litigator out of Texas. It sort of has the appearance of another pro bono intervention, but that's just my hunch.
Or it could be some securities brokers are funding the
That's
funding
good.
the.
Yeah, that's a good point too. Yeah.
Well, Damien rehearsed this perfect transition into the return of advocacy for Miss Elizabeth Prelogar going up against Miss Lisa Blatt in TM versus University of Maryland. So it was great to see Prelogar back. Interestingly, she was not counsel of record on the petition or even on the merits briefing. It was a different prominent SCOTUS attorney, Cameron Shamagam, and somehow Prelogar got to argue this case. But it was nice to have her back in. It's her first argument since being Solicitor General. Damien, what was this case about?
The Rooker-Feldman doctrine, it's funny, I used to have a colleague here at PLF who said that doctrines don't really get established in federal court until you've got two cases, and then you can refer to them as Rooker or Nolan Dolan or what have you. But anyway, so Rooker-Feldman, as I understand it, is simply the case law made doctrine that district courts, federal district courts, are not appellate courts, and therefore they cannot review the lawfulness of state court judgments. And that here, there's some, I don't know the underlying case specifically, but there was a consent decree entered into between the petitioner and the respondent hospital group. And the lawsuit that was filed in federal court was trying to undo that consent decree in state court on the grounds of duress.
I think the consent decree, just to stop you, if I remember correctly from when this was granted, I think it had to do with involuntary commitment or a commitment into some sort of like psychiatric ward for a period of time.
Okay, very good. So that probably then is related to the duress argument for why the consent decree should be, I think Oliver is typing his mother.
Yeah, he's got a loud keyboard.
In any event, so the issue is the scope of the Rooker-Feldman doctrine, meaning does it, as petitioner I think is arguing, does it really only apply to federal cases that are seeking to attack or otherwise review the final decisions of state Supreme Courts, or is it broader than that? Does it include, even in this case, a lawsuit that's trying to seek some sort of collateral review, at least, of a state trial court judgment? Mm-hmm. And the argument reflected, I think, some judicial concern with the Rooker-Feldman doctrine, but also almost universal dislike of the idea that this is the right case to limit Rooker-Feldman. I think Justice Alito had a question where it was something to the effect of, well, Rooker-Feldman, we could say that only cases where the party's names start with R or F, but everything else will be okay. That would limit it, wouldn't it? But that wouldn't make much sense. And his point being that if we're concerned about district courts exercising appellate functions, presumably that's a concern that's in place whether it's reviewing in an appellate fashion a state trial court, a state appellate court, a state Supreme Court judgment. So I think that that was the problem. Justice Gorsuch, I think, pretty clearly indicated that he thinks Rooker-Feldman is totally improper, but I suspect that most of the court's going to reject this attempt to limit it. Lisa Blatt, for the respondent, she had a very good point straight out of the gate that petitioners were saying, oh, you have to worry about all these federal cases now that will try to revisit state court judgments because there are things like preclusion doctrines, res judicata. And she pointed out again and said, well, that's great, but that doesn't even apply here because they're arguing that the judgment was entered into by duress, and so it's something that came up afterwards, so it wouldn't be a preclusive issue. And it was a little in the weeds, but the point being is that the petitioner's supposed safeguards apparently weren't even really implicated in this case.
Right. Yeah, that's a very good summary. Thank you, Damien. My question is on the preclusion doctrines, res judicata, and collateral estoppel issues. This shows my ignorance of these doctrines, and if collateral estoppel applies, if issue preclusion applies, or other preclusion doctrines apply, and you can bring why bring your federal court lawsuit then? I mean, if what you litigated below is binding in sort of like what they found on certain issues, I don't see what value you get in, if those questions aren't open to you in a federal forum, what value is the federal forum to you?
Well, and I think that was Ms. Blatt's point, is that petitioners were hoping that preclusion wouldn't apply in the state trial court, and so that they would essentially, at that point, then get a de novo adjudication of what was resolved in the state court action that was then on appeal. It's currently still on appeal in the state court system.
Yeah, but conversely, I would say, like, so I'm sort of like generally of the mindset that these preclusion doctrines and these sort of ways to kick cases out of federal court are generally on the side of plaintiffs, right? That they should be able to bring their cases, and that oftentimes the Rooker-Feldman doctrine, I've seen it stretched to scenarios where it ought not apply. But I guess if it doesn't apply, let's say that the TM wins here, I would think that preclusion stuff shouldn't apply either. Like, if you have a right to bring your case in federal court, notwithstanding some initial state court judgment, then why should you be bound by the state court decisions?
I think the answer there might be that Rooker-Feldman is a gloss on the jurisdictional authority of district courts, whereas preclusion is a merits argument.
Yeah, and I think that's the strongest argument that I think the plaintiff had, the petitioner had here, is that the jurisdictional statute, was it 1331 or whatever it was, 1346, doesn't contemplate not having the ability to bring this in federal court. So you're sort of restricting federal court's jurisdiction, which it's supposed to unflaggingly accept jurisdiction. I think that's the quote that we always use in these cases. And if the statute doesn't preclude it, then why are we creating a judge-made doctrine where the statute doesn't contemplate it?
Yeah.
All right, anything else on Rooker-Feldman, Oliver?
No, I have nothing on Rooker-Feldman for me.
All right. The last case that was argued this week was Blanche versus Lau. Blanche being the acting attorney general, Lau being a LPR, as we learned. It's everybody's favorite new acronym that was used over and over and over and over again in the oral argument. LPR meaning lawful permanent resident, green card holder in more layman terms. This case concerned an individual who had left the country, lawful permanent resident, green card holder, left the country, was suspected or convicted. Damien, do you know what the actual circumstances?
Charged. I think there was an indictment, yeah.
Indicted with counterfeiting in a foreign land, and came back and was, well, Damien, why don't you take it over there and sort of rest the table?
Yeah, and believe me, I mean, it's an incredibly complicated issue, but as I understand it, there's a default statutory right for green card holders to come back in, just like citizens.
Right.
You know, that
you just get the stamp when you come to the border. So
yep, exactly. But Congress has provided, I guess there are a half dozen exceptions to that automatic reentry. and some of them dealing with crimes of moral turpitude. And the one at issue for this case is whether the immigration officer concludes that the green card holder has committed a certain crime of moral turpitude. And the question, as I understand it, for the Supreme Court now is the standard of review, or the standard of evidence, the degree of evidence, that's a better way to put it. How much evidence does the immigration officer have to have at the moment the person comes back at the airport seeking re-entry? The government was saying basically it's just, it's like, not necessarily like probable cause, but it's like to the satisfaction of the good faith of the immigration officer. Whereas the challengers here are arguing that no, it's clear and convincing that that the immigration officer must have clear and convincing proof that the LPR has committed one of these crimes of moral turpitude.
Right, and so if I can take it over from there, so you can imagine at the border, we've all crossed the border. I don't know, Oliver, have you crossed the border?
I have crossed the border.
Ohio to Florida? There's no border there. Anyway, that when we cross the border, it's, it can be a pain in the ass process because the line's long, but ultimately the guy at the border, the lady at the border looks at you, stamps the passport and says, welcome home, or something like that. It's not the point of time where they're making a substantial evidence determination or clear and convincing evidence. It's a ministerial act usually that these officers are engaged. Maybe they type your name, they scan your passport, whatever they're doing, whatever comes up on that computer, they're stamping you and moving on. And so presumably when they put this guy's name through the computer, it came up counterfeiting in wherever he was, China. And based on that, he's like, all right, we're going to put you on, it's not called probation, what was the term that they used for it?
Parole, and it's an oddity that I think Justice Kagan even noted, because that it's precisely because they think that you've committed a crime that they're putting you now on parole.
Okay.
But as I understand it, the idea is that the parole means that as a matter of law, you have not yet been granted re-entry into the country. Even though de facto you are in the country, as a matter of law, when you're on parole, you're still considered like at the airport.
Yeah.
And the reason why that's significant is that then if they decide that they want to kick him out, it's a lot easier, I guess, legally to do it, or maybe there's less process required to do it if the person isn't officially hasn't officially re-entered.
Yeah. So I thought there were a couple of interesting moments at oral argument in this one. I thought Dvoretsky, who's an experienced Supreme Court litigator, was arguing for the LPR. And at one point, Justice Alito asked him the hypothetical, let's suppose that someone shoots somebody in France, gets on the airplane immediately, and now the immigration officer at the border gets a phone call from French authorities saying, hey, this guy just shot somebody and got on the plane, can you detain him? Obviously, they don't have clear and convincing evidence that the person did it. Could you detain him under this crime of moral turpitude? And Dvoretsky's like, no, that's not clear and convincing evidence. You can't detain this person under that set. Now, at that point, the Chief Justice butts in. He's like, because I think Sotomayor didn't like that line of questioning, and so she tried to save him. And the chief butts in. He's like, I'm sorry, was your answer no? And he said yes. There's no clear and convincing evidence. The answer, and they went over, and he recovered after that, being like, well, look, if they have probable cause to arrest him, then they can arrest him under their general police powers as like a police officer. But under this sort of statutory authority to detain him, they don't have clear and convincing proof. It felt like that sort of gave the game away at that point. That I also think it, as someone who's pretty pro-immigration, the idea that these officers have to hold many hearings when people are walking through the door seems a little bit crazy to me. Now, maybe the retort to that is, well, crazy or not, that's the one that Congress wrote into the statute, so we got to follow that. which I understand that argument. The other interesting note on oral argument, at one point, Justice Jackson had like, I don't know, in the transcript, it is a 3-page question back in the style of Breyer. I'll say Breyer was a little bit more, Breyer would actually be asking a question. It would be a hypothetical, like what he asked at me when I had oral argument. He had this hypothetical about spaceports and whether you could, in the future, if everybody has their own space mobile, whether the government could come on and inspect the spaceports. But he actually was getting to a question. Now the hypothetical would take 2 or 3 pages, and it was always sort of, old Grandpa Breyer coming up with a nice hypo, and it was fun. But Justice Jackson's not coming up with a hypo. She's just going on like a diatribe of how immigration enforcement is this crazy thing, and yada yada. And it's like 3 pages of that. At the end, she says, "And what do you think about that?" Or something like, "What's your response to that?" To which the Solicitor General says something to the effect of, "Well, if I don't think we can go off the assumption that the entire United States government is in a conspiracy against all immigrants at all times," or something like that. And she said, "Thank you," and ended the question. Just, I don't know. It just strikes me as a little bit beyond the pale. But anyway, I thought, any other thoughts from this argument from either of you?
Nope.
Any predictions on how it's going to come out, Damien?
I think the government's going to win. I mean, in part because it seems like even the sort of, for this case, undisputed requirement that there's a clear and convincing evidence standard at any point in the process, even that seemed to be contested. Justice Thomas noted that was not in the statute itself. So, and as you say, Justice Barrett too, more than once said, how are you going to have these people do the adjudications at Newark Airport and security law? And the comebacker is, well, that's the whole point. They know that you can't do the adjudication, so effectively then you won't be able to use this power to prevent really anybody. And that seems to be thwarting Congress's intent the other way. So I think the government will win.
And it also seems like paroling is sort of the less extreme option than actually detaining,
right?
Which is ultimately what they would end up doing for situations like this, I think. Now, I am sympathetic to the idea that, look, when you attain lawful permanent resident status, you're basically a citizen, and you should have a right to enter. It should be a high bar for you to be denied entry into the United States. I get that. I just feel like I'm sort of with Damien. I think they're going to come up the other way. I think there's just too many difficult questions that this would raise. Now, ultimately, I think that there will be a clear and convincing standard to actually prove paroling is necessary, but that initial determination, there has to be something that is below that they can make at the border.
This is also another, speaking of advocates, another instance where I think maybe there was pro bono intervention here, because Mr. Duretsky did not represent the Mr. Lau below. So,
Damien, it feels like you have a comment to make about this pro bono representation of.
Well, I do find, because we've talked about this before on the show, how if you want to make it in Supreme Court practice, maybe one easy way to get experience is to either work for the Solicitor General's office or to offer services for free and get the clients that way. But you would think that wouldn't be necessary once you're already in that established 24 number or what have you, sort of well recognized. And yet, you had it with Ms. Prelogar. You had it, I think, you had it with Mr. Duretsky, and maybe also in the Shrikich case, where it seemed like you had experienced counsel who maybe were getting involved in a pro bono context. And I just wonder what their thinking is, because they don't need the experience. They don't, and as far as the reputation goes, you think it's already established. So I'm
well,
curious.
maybe not if they haven't appeared in 5 years. I don't know.
Yeah.
Because they don't make. We're Damien or Josh and I talked about this just before, but there've been a few moves recently by big name Supreme Court lawyers moving firms, and the one article I saw talked that they don't bring in a ton of money compared. The corporate work is what brings in the money, Now, these guys do counsel on people at trial to say how to avoid these kinds of questions, what are likely to be appealed, things like that. But the Supreme Court practice itself does not bring in the same, it brings in money, not the same kind of money. And so there must be some reputational advantage to appearing at least once a year or something.
Yeah, I was thinking that at least in part, having a long list of Supreme Court cases where one is argued would be beneficial when pitching one's services at the appellate level to companies that would pay.
Yeah.
But again, even appellate briefing must pale in comparison, appellate work in terms of the dollars that it brings in when trial work does.
You know, I would still like to know though, what I had just forgotten, what I was going to ask, and I've completely forgotten, so never mind.
Must be important.
Yeah, it must be important, yeah.
Yeah, I'm hard being the youngest person on this show today. You old guys. We have 4 opinions, some interesting ones on cases that we've covered on the show before. Oliver, let's talk about Chevron.
Sure. This is a case that involves removing a case from state court to federal court. And there's a statute that allows an officer or a person acting under that officer to remove state suits for or relating to any act under color of such office. And so here, Chevron, a predecessor of Chevron, did work for the United States government during World War II, helping to fuel our airplanes and tanks and everything. And then much more recently, Louisiana passed a law to protect its coastland. A lawsuit was brought against Chevron and others in state court. And one of the experts for the plaintiffs said that they were going to get into work that Chevron's predecessor had done during World War II. And so Chevron and other companies said, fine, we're moving to federal court under that statute. And so even though the part of the lawsuit, at least, was not directly related to the work that Chevron's predecessor had done during World War II, nonetheless, the question was whether the suit was for or relating to any act under color of such office. And the court unanimously held that it was so related, and therefore that the case could be removed to federal court. Justice Alito recused himself for who knows what reason. And the only other interesting tidbit is that Justice Jackson concurred in judgment only. She said that based on legislative history, the connection between the issues, the questions at issue in the lawsuit and the prior work or the work under color of the office had to be tighter, there had to be a closer connection. But she held that Chevron had met that close connection in this case, and so she agreed with the judgment.
She continues to beat the drum on legislative history, and she continues to be the lone voice beating that drum. But another removal case, Damien, was Enbridge Energy versus Nestle.
Yes. As I understand it, so there was a lawsuit filed against Enbridge by the state of Michigan, or Michigan Attorney General, in state court. And while that case was being litigated, a new action was filed in federal court by the state against Enbridge. But then that was dismissed. And so then after that federal case was dismissed, Enbridge then decided to exercise its removal authority under a different statute than what was at issue in the Chevron case, to bring the case from state court into federal court. And the problem was, though, that this removal statute at issue says that you normally have to do it within 30 days of, I think it's 30 days of the complaint being filed. And of course, this was like 2.5 years afterwards. But Enbridge was saying, well, the 30-day period for removal should be equitably told because we were kind of led on by Michigan when they filed basically the same case in federal court. And so we were thinking, okay, well, we'll be able to litigate the issues we want to in a federal forum in that case. But then
Michigan, when that one was filed, they stayed in the state court action, so nothing has even happened in the state court.
Correct. But then Michigan decided, no, we're gonna drop the federal district court case, and so at that point, Enbridge was stuck in state court unless it could argue for tolling of the 30-day period. So Justice Thomas, in a unanimous opinion, held that although this 30-day time period for removal is not jurisdictional, nevertheless, it's mandatory, and that the court would not read into the statute the ability of courts to basically stay the 30-day period for equitable reasons. And, it's an interesting case because there's some carryover to one of our more recent Supreme Court cases at PLF, Wilkins versus United States, where the issue was whether a statute of limitations was jurisdictional or not. And of course, one of the reasons why we wanted to argue that it's not jurisdictional is precisely because it at least gives you the chance to argue for equitable doctrines like equitable tolling or laches or what have you. Now, this case that for Enbridge just goes to show that, well, it gives you the chance to argue it, but by no means are the courts going to automatically assume that just because a provision is not jurisdictional, that it's subject to all sorts of equitable exceptions.
Yeah, I'll have to say, I was a bit surprised that this is where the judgment landed, for a couple of reasons that, maybe I wasn't paying attention that hard during oral argument, but this is like a big multi-million-dollar pipeline from Canada through America. It seems like a case that ought to belong in federal court. It also seems like Michigan sort of like gamed its way into having a state court action by filing, I think one was by the Attorney General, one was by the governor, and then they stopped the state court action and started litigating in federal court. It just seems to me, for all those reasons, that the court was going to side with the oil company here, but 9-0 against. The only other thing I'll add is my very first opinion that I ever got written at PLF. I'd been here for about 3 months, and I filed a motion to remand based in part on the 30-day limit being exceeded, and the city and county, or the Port of Oakland, who I was suing at the time, argued that no, you should toll the 30-day timeline because we didn't realize that this case had a federal issue, which was absurd. We didn't argue that the 30-day limit was unwaivable, but we just argued that they obviously knew about the federal issue at the time the complaint was filed, and I won that issue by, speaking of Breyers, Charles Breyer issued that remand, and it was the first opinion I ever got at PLF. Two other cases that we can move a little bit more quickly through. I'll do the first one, which is a per curiam decision. This is DC District of Columbia versus RW. This was a police officer who was told that there was a suspicious vehicle driving along at night in DC in a certain area, pulled behind the car. The facts are basically two people quickly jump out of the car and start running. The person driving the car with the doors open starts backing up and going. And the DC Circuit said, no reasonable suspicion there. Perfectly normal behavior at 3 in the morning. The cop didn't have the right to seize and of course he seizes the kid the minor who was driving, and finds.
That's how Damien gets out of all kinds of trouble. No reasonable suspicion.
So the Supreme Court writes a per curiam opinion, basically saying, obviously there's reasonable suspicion here. This isn't, it's beyond question, and therefore per curiam is appropriate. Interestingly, Justice Sotomayor would not have granted the petition. Just doesn't say why, but just dissents on the grant. And Justice Jackson dissents with an opinion, which, I can kind of see. She basically says, we're sort of parsing the Court of Appeals language here. It's error correction at best. That's not what the Supreme Court's for. We're not making law here. Why are we going to bother? And, that is a reason why the Supreme Court purports not to take cases. Count me in for the Supreme Court correcting errors more often in something like this and other cases that come to them that are obviously wrong. just correct them. I mean, that you're the Supreme Court. So I have no problem with this opinion. Any thoughts from you guys?
I wonder too if there's something going on. Is we all know that the current administration has made crime control in D.C. a big deal. So I think maybe that's playing into it as well. That maybe the court is a little more solicitous of the efforts of the D.C. police and thought it was an appropriate correction. I mean, I think the legal error, the petition itself was not presented as a per curiam. I mean, it was arguing that there's some disagreement in the lower courts about whether it's a single factor or multi-factor analysis, or whether you can just look at one factor of whether you can have a seizure. But anyway, I suspect that might have been something of what was going on. But it's the third or fourth, I believe, per curiam criminal law decision from this term, if I'm not mistaken.
Yeah, agreed. I was trying to look to see when this actually happened, whether it was during the Trump administration's reign or whether it was, because it would be rare for a case to get all the way to the Supreme Court within 12 months. So it's
That's
probably
true. Yeah, that's true.
policing that was. But
Could have been from the first Trump administration.
Yeah,
Yeah, that's true.
I don't see anything obvious from my glance at the opinion right now from when the stop arose. The last opinion, Damien, talked to us about Fluor Corporation.
Yes, so this was a state tort negligent hiring supervision action brought by a federal contractor brought by, was it a serviceman or, well, someone who was injured working at a military base in Afghanistan when the defendant contractor's Afghan employee turned out to be a Taliban operative and who, in the process of committing a terrorist suicide bombing, caused grievous injury to the petitioner. And so it was litigated as a state court tort action under South Carolina law, removed to federal court. And the argument of the defense contractor was that we should enjoy the federal government's sovereign immunity, which is pretty much impenetrable when it comes to injuries sustained on a military base in active use, as this military base in Afghanistan would have qualified. And the Fourth Circuit said, yes, you, contractor, are immune, despite the fact that the Federal Tort Claims Act exception for military activities only applies to, on its face, to the military itself, not the contractors of the military. So the Supreme Court granted review, and in an opinion, I believe a 6-3 opinion written by Justice Thomas, sided for the petitioner plaintiff and held that the defense contractor does not enjoy sovereign immunity, and more accurately, not so much doesn't enjoy sovereign immunity, but that the tort claims are not preempted by federal law. That there is no federal statute that forbids parties from being liable for under state tort law for injuries sustained while on an overseas military base. Now, the dissent written by Justice Alito, I think, takes the view that now you're opening the doors to state court judges and juries essentially regulating overseas bases. But here, facts are particularly good for the challenger, for the petitioner, because there, really, there was a military review of what happened, and that review said that, yeah, this contractor was negligent in hiring this fellow. They should have done a better background, and that they weren't supervising the event.
I remember from oral argument, the company's counsel was like, of course the military is going to say that, because if they don't say that, then they're the ones liable and they're going to get sued. So they're going to try to pin it on us.
Mm-hmm.
And so let's take a step back here. We're doing the military's bidding. We're overseas, yada, yada, yada. So yeah, maybe it is good for the petitioner, the plaintiff in this case, because of that fact that the military is trying to pin the blame on them. But I also feel for the company here. They're like, we're stuck between a rock and a hard place. On the one hand, we got to please the military, and then the moment we're following what they tell us to do, now we're subject to litigation in state court as well. We don't get any military
Well,
acceptance.
subject to litigation, but right, but I mean, they can still prevail, right? I mean, they're still able to say, oh, we were just doing the military's bidding in the contract,
Yeah.
which I think even the petitioner here, or the petitioner would acknowledge would be a defense.
Yeah.
That if they were simply following what the contract required.
I think there's a bigger story here. The Fourth Circuit was not reversed.
No, it was.
Oh, it was.
It
Oh,
was,
okay.
yes.
Well, but never mind. That sounds right. They are awful right now.
Well, but it's also interesting to note. Justice Thomas wrote the opinion. I think it just goes to show that preemption arguments that are based on conflict preemption, which this basically was, that there's some sort of penumbral policy around the statute that protects contractors as well as the military itself. I don't think those have 5 votes.
Well, once again, this crazy right-wing court is ruling for Governor Whitmer over the oil company, and now ruling for the tort plaintiffs over the military contractor. So, it just goes to show. All right, well, those are the 4 opinions. I do want to touch on some things, some Supreme Court gossipy or interesting things that happened over the past 2 weeks since we last spoke. Let's talk talk first about Justice Sotomayor and calling out Mr. Kavanaugh for
His privilege.
His privilege. So she was speaking at an event at the University of Kansas School of Law, and she says, quote, "I had a colleague in that case who wrote, these are only temporary stops. This is from a man whose parents were professionals and probably really doesn't know any person who works by the hour."
Well, first of all, she's right on the merits of the opinion, but everything else is just ridiculous.
Yeah.
It's just, his kids, he sent kids to school, so there's got to be some hourly workers there. There are people at the court who work by the hour. It's just a ridiculous statement.
Now, coming full circle, a week later, she did apologize, and I'm trying to see what the actual apology is. If I have it here, she called her remarks inappropriate, indicated that she had personally apologized to Justice Kavanaugh. The Supreme Court actually issued a press release saying that. So, good on her. Everybody, I've become heated myself, and certainly over opinions that I think are wrong. So, all you can do is say mea culpa when the moment strikes it. The other, I kind of found to be a nothing burger, but was also a big story at the time, or maybe even last week, was the purported leak at the New York Times. The New York Times reported that one case. Now, do you remember what the case was, Oliver?
Is this the shadow docket?
This is the shadow docket leak.
Yeah, it was when Obama was trying to expand. What it was, but when Obama was trying to expand the EPA
Clean Air Plan.
Yeah.
Do you remember, Damien, what the underlying issue was?
No.
Damien doesn't read the news. So this is the first Supreme Court leak since the famous Dobbs leak of a couple years ago, where the Alito opinion was leaked and the Supreme Court launched an investigation. This is the leak of, I guess, like back and forth emails and drafts from the justices on whether to grant emergency relief for, I can't remember if it was the coal plant or one of Obama's major environmental initiatives. And I don't know. The reason I think it's a nothing burger is because it just shows like the justices going back and forth arguing why they should issue the relief or not, and some had different opinions and others didn't. And like, yeah, that's kind of what they do. And I think the New York Times was trying to paint this as this was the unprecedented first instance of the court using the shadow docket to stop major policies from going into effect. Who was it? One of our friends at SCOTUS blog pointed out that there were like a number of these in like 2010 and 2011, 2012, and it wasn't really like the first instance of it, that the court at times would have to use its emergency docket to grant relief. And I don't know. I don't know if there's more of a story there, or if I'm missing what the big reveal of a gotcha was that the New York Times, the big scoop, but it felt pretty unmeaningful to me.
Yeah, it was just there was some criticism of Roberts because he wrote the first memo, but it was from the DC Circuit, and so he's the justice that hears or gets those applications initially. He wrote a memo suggesting here's what we should do. I think the unprecedented, as far as I can understand it, is that the DC Circuit had not yet ruled. So it was issuing a stay in a case before the DC Circuit had even heard the merits. So that was a little different than the ones that were discussed in that SCOTUS blog piece you mentioned. But there were also some different circumstances. The Chief Justice noted that there was an administration official who bragged that judicial delay in another environmental context had basically baked in the policy. And so the chief said, we should avoid this. It's going to cost companies incredible amounts of money. It's irreparable harm. So there were the people who complain about the shadow docket don't also seem to complain about the expansion of executive authority and executive policy making that has, the court isn't just jumping into these things for no reason. The executive is taking these huge swings.
Right.
And as we know, courts can be very slow to act. How many times have we lost a preliminary injunction motion or not gotten a ruling for months? And so, frankly, I'd like to see courts get involved more quickly. At least put a pause on it and then issue that. I think there's bigger criticisms of when the court makes big substantive decisions on the shadow docket, but issuing a stay doesn't seem like a big deal to me at all.
Yeah.
And if I may, the one thing that about the New York Times article that bothered me is there were things like Justice Roberts was anxious to do this. How the hell do they know? I forget exactly what the words are, but it was something like that. It was just, again, he wrote the first memo. He's the one.
Right.
He wanted to do something, so he wrote a memo to his colleagues. So it's just some of that was a little over the top, I thought. And one other comment, something like in all the memos, not one of the justices mentioned the harm to the planet that global warming threatened. They're not. You want the court making policy decisions now? Is that the? Now I think the point was there's the whole take the big picture into consideration. But anyway, I'm with you. It wasn't a big deal, except that I think the big deal is, as everybody I think recognizes, is that these memos are getting leaked 10 years after the fact. Someone's hanging on to these things, and it makes it our justice is going to be as free as they were before, putting their initial thoughts on paper and sending it around.
Yeah, two thoughts, a couple of competing thoughts on that. One, it is a little bit unseemly that we are still dealing with leaks at the Supreme Court. And I think now we've had, 2 in whatever time this is. You got to think, hopefully this doesn't signal that we are going to increasingly get more leaks. At the same time, it's been 11 years since this case. Some memos on the court's thought process, I don't know. I find it interesting, even if I don't find it sort of like a gotcha by the New York Times. I don't have a problem with this information being out there openly. Like, why not reveal some of these memos? I know usually when a justice retires and publishes their book, we get a lot of internal stuff, and that stuff's really interesting to me. And I think, this how the court works. and having more information on that, I don't really think it hurts the legitimacy of the court. I think in a lot of ways it strengthens it. As you said, Oliver, the fact that they come to decisions through argument and memos is refreshing. It's not, you don't want them making policy judgments. You want them thinking it through, and this gives us a glimpse into how the court actually did it in this, important case.
Well, it was interesting. On SCOTUS blog this week, there was an article with a prominent Brazilian attorney, professor, talking about the Brazilian Supreme Court and contrasting to the United States Supreme Court. And one big difference is that, at least for some types of cases, the Brazilian Supreme Court justices debate the case in public.
Oh.
And that's a very controversial thing in Brazil. I think we should adopt that here every now and then. I think that would be I think that would be a somewhat refreshing to see the justices. I mean, it kind of already happens in oral argument now.
I was just going to say, yeah.
But it's
certainly
much
is
more indirect. But
Yeah.
it might be a trial.
All right, a few final things here. We had 2 grants. I think the less interesting one, there was a gun in possession case that's raising Second Amendment issues about a felon, convicted felon. I didn't get the details, but whether that individual can possess a gun consistent with the Second Amendment post-Bruin. I don't know if either of you have more to say on that case.
I know even less than you do.
The second one to my two Catholics here deals with a Catholic preschool in Colorado that wants to avail itself of some students that essentially a school choice scheme. There's free preschool in Colorado. The Colorado, why is it always Colorado? Like Masterpiece, says no to the Catholics. Meanwhile, they apparently had allowed schools to select students on the basis of race, had allowed schools to select students on the basis of sexual orientation. But the moment that the Catholics want to instill their morality in their schools and select kids on that basis, that's when they say, no, enough's enough. Racial discrimination is fine. We just don't want the Catholics doing it.
Yeah, the interesting thing about this cert grant is that there were 3 questions presented. The court accepted only 2, and the question it did not accept was whether Employment Division v. Smith should be overturned. That's Justice Scalia's opinion, which applied a what was that? It involved peyote, and it was whether the laws that have general applicability can remain on the books, even if they have the effect of restricting the free exercise of religion.
So it feels like it's another opportunity for the court to smack down Colorado, to smack down and limit Smith again without overturning it. I wonder why they didn't take that 3rd question, or just that 3rd question. I know Roberts is the minimalist and wants it, or incrementalist, but it feels like they've done this so many times now. Why do we need another one?
Well, this was an express. Sometimes it doesn't come up and they avoid it, but here they had a chance, the questions presented, and they say, nope, no thanks.
Yeah, I mean, I think one hypothesis is just that they don't have 5 votes. So they don't think they have 5 votes to just simply scrap it.
Yeah.
But it is interesting. You don't think of, say, Colorado as being, particularly more progressive, say, than California, right? Or Oregon or what have you. Does Colorado just simply have incredibly stringent laws that the other progressive states don't have or don't enforce? It does seem strange how they all seem to be. It is 3 cases now, right? There was the cake, and then there was the wedding designer website.
Yeah.
And now this one, yeah.
Now I think those other cases
and even Childs, wasn't Childs the free speech one from that was also Colorado,
that was also
conversion therapy.
Yeah.
Yeah,
right.
But the Christian Baker and the website, I think those claims were brought by the Colorado Commission on Human Rights, whatever that is. So that is some loony thing. But this is more. It seems like more of a statutory question. So I don't know how that works. Are your kids calling, Joshua?
No, it's funny. The name that came up was John Roberts.
We love the Supreme.
Now, I do know a John Roberts in New York City who is a plaintiff in one of our cases that went to the Supreme Court, so
Very
start with
good.
him, but maybe the chief is, okay, a few last minute items. Speaking of Supreme Courts, the California Supreme Court issued a big win for PLF. So I want to mention that. Damien, you want to give a quick rundown of what that case is about?
Sheer Development versus California Coast Commission. Our client was trying to build a modest residential subdivision in San Luis Obispo, a central California coastal county. And he obtained the approval of the county, but the California Coast Commission, which also had jurisdiction, so to speak, over the area, said, no, we don't like the permit. We think it's going to cause too much environmental harm, even though we need housing in the state desperately, so we're going to nix the permit. And our argument on appeal in the California Supreme Court was principally that the Coast Commission here had no appellate authority to review what the county had done. And the state Supreme Court, in a unanimous opinion written by the Chief Justice, ruled in our favor, said that the Commission was not entitled to any deference in its interpretation of the relevant provisions of law, and that on the merits, the Commission did not have appellate authority over this type of home development permit. So big win for the clients, but also big win throughout the California coast, which has some of the worst housing problems in the nation, that this will make it a lot harder for the Commission to intervene in local government development approvals, which we hope will then mean that there'll be much more housing built on the California coast, which will bring down the cost of housing and make the populace much happier.
And the California Coastal Commission might be the most lawless agency in the United States. So this is it's to such an extent that the California Supreme Court unanimously ruled against it. So it's just fabulous.
Yeah, agreed. Great opinion. We have a number of cert petitions coming up, so we're certainly crossing our fingers as the Supreme Court is hearing some of its final cases this term. We only have one more week of oral arguments. So we'll be back next week with our Supreme Court show to talk about those cases, and then we'll be waiting for opinions. So the term is winding down. Well, fellas, I got you for a couple more minutes, so let me do some Supreme Court trivia for you. All right. So I'll ask it this way. Of Thomas Jefferson, Abraham Lincoln, and Grover Cleveland, which...
Sorry? Start over.
Jefferson, Lincoln, and Grover Cleveland.
Yes.
Which had the most appointees to the Supreme Court? Damien?
Grover Cleveland.
I was
Oliver?
going to say Cleveland.
You were both correct. Very good. Appreciably so. All right. Name one of Jefferson's 3 nominations to the Supreme Court. He only had 3 for his 8 years.
Surprised you had that many. Randolph.
No.
Story?
William Johnson, Henry Brockholst Livingston, and Thomas Todd.
Yep.
I didn't know any of them.
Yeah.
Lincoln had 5. Can you
What?
name? Yeah.
Chase.
Chase, Salmon,
Field?
Stephen Field, longest serving. And then also Noah Haynes Swain, Samuel Freeman Miller, and David Davis.
Mm.
All right, Grover Cleveland. You guys get any? He had 1, 2, 3, 4, 5, 6, 7, 8.
He had 8 Supreme Court appointments?
Yes, through 2 different, he had staggered terms, but yeah, he had 8.
Lord.
Harlan?
Nope,
Holmes?
nope.
Hughes.
White.
Edward Douglas White. There you go. You got one.
Hughes?
No Hughes. You gotta get one done for before I let you go.
Taft.
No.
A little early for
A
Taft.
little early for Taft.
Pitney.
Yeah. I think that the two, I'm gonna give you one more chance.
The other Harlan.
There's two that you could have gotten, I think. Fuller, Chief Justice Fuller,
All right.
and Peckham.
Okay.
You also had Lucius Quintus Cincinnatus Lamar II, Horace Gray, David Josiah Brewer, Henry Billings Brown, George Shiras Jr., and the other ones that I mentioned. All right, guys, it's been a pleasure. We'll see you next week. Thank you to our over 100 current listeners for tuning in. We're always available on YouTube, the replays of the episodes, so please share widely. And we'll see you next week with more Supreme Court musings from your liberty lovers at PLF. Thanks, and have a good weekend.